Good morning again, everyone. Thank you for joining. So as I say, we've run that Menti poll and people have been completing the questions as we've gone along. I'll just share that screen. So the results there, I think you can see them now. In terms of the key priorities for HR organisations in the health and care sector in 2021, recovery and wellbeing, perhaps not unsurprisingly featuring prominently there. Restoration, health and wellbeing. So a clear message coming through from those slides. Okay, thanks for doing that. In terms of who's presenting to you this morning, so this is the first National Health and Care webinar that we've run as a health employment group at Mills Reeve. So we've got speakers drawn from across the country or from across their homes across the country. Particularly pleased to welcome Andrew Utley, who's joined our Leeds office as a principal associate and who's going to be speaking this morning. Just a few words by way of housekeeping. You'll have heard that I was interrupted by the recording starting when the webinar worked. So this is being recorded. Feel free to please submit your questions in the Q&A box as we go along. It may be that we'll deal with questions at the end, but if there's a really magic question that fits in as we go along, we can deal with it then. And then at the end of the webinar, when you log off, you'll be asked to complete a housekeeping survey. And if you can do that, that would be much appreciated. So what are we going to cover today? Well, you'll have seen from this morning's papers that today is the year to the day since the first lockdown. And it's been a year like no other for employers and employees across the economy, but particularly for those in the health and care sector. So the impact of the pandemic continues to be felt and is undoubtedly going to reverberate across the employment landscape as we move forward. And that's reflected in the topics that we're going to be talking about this morning. Indeed, you'll see that COVID-19 has a section all of its own. And so Fiona is first of all going to look at the issue of vaccination and the workplace. Survey is then going to look at planning for the future, post-COVID, and in particular, the potential for increased flexible and home working. Andrew's then going to look at diversity, inclusion and wellbeing before Emma and Rebecca are going to round up by looking at some of the latest on the holiday pay and there's two other key cases, in particularly the MENCAP case. So without further ado, I'm going to hand over to Fiona. Is Fiona there?
Oh, apologies, everybody. I made the classic mistake of being on mute. Well, good morning. I'm going to talk to you this morning about vaccination, as Stuart said. On the next slide, please, Stuart, I've just set out an overview of what I'm going to talk about. I'm mainly going to focus on options for you if your members of staff refuse to have the COVID vaccine and the ongoing debate about making the vaccine mandatory. But at the outset, I did think it would be remiss if I talked about vaccine without just acknowledging the success of the vaccine programme to date. And I'm conscious that many of you on this call have played a direct role in the success of that, and it's been a lot of hard work for you. So if it's not too cheesy, I wanted to start by saying thank you. But let's dive in and look at where we are with the take-up of the vaccine amongst the health and care workers. So the most recent data we have is from the 7th of March. So hopefully, one would expect these figures to have risen a little bit since then. But we're looking at nearly 95% of frontline health workers having had the vaccine, which personally I think is a significant success. but there are pockets within that. We're looking at just under 81% being vaccinated in London, and the current figures for care workers are significantly lower, around 62%. As of the 7th of March, I think that figure is currently around 70%. And the data indicates that there's a lower take-up in groups from lower incomes and also some ethnic minority groups. In terms of the roadmap out of lockdown, I think the broad direction of travel is pretty clear now, and the routes are reasonably clear from the press releases. There are 4 reviews ongoing, which will assist the government in identifying when the various measures can be eased. The first review is to assess how long we need to maintain social distancing and wearing face masks, and it will also inform the ongoing guidance as to working from home. Obviously, at the moment, this is to continue wherever possible until this first review is complete, and it looks like this is going to be around the 21st of June, but there have been various cautious statements made in the press about an ongoing need for some continued measures, such as use of face masks. And I think this is born out of an awareness that it may take the global vaccine programme several years to conclude. And I think most of us expect that we will be using face masks, etc., for some time yet. Certainly NHS England and Improvement have said that vaccines are not a replacement for PPE, hand washing and social distancing. I mean, just quickly, the second review relates to international travel, looking at when that can resume, possibly the introduction of vaccine passports. But again, there have been some very cautious statements made by government ministers about the likelihood of international travel this summer. The third review is about COVID status certification. This will look at the potential role that certificates might play in helping venues to open safely, and looking at various concerns relating to that, including privacy, ethical and legal issues. And the fourth review is about major reviews and the possibility of using testing to facilitate the opening of those. So how can we encourage the take-up of the vaccine? Onto the next slide, thank you. The approach within the NHS has been to engage with and seek to persuade staff to have the vaccine. So on the 4th of March, Parana Issar, NHS England's Chief People Officer, wrote to organisations stating that those staff who hadn't had the vaccine should be met with, and a one-to-one discussion carried out by their line manager, and this was to have been completed by the 12th of March. The direction was that the conversation should be approached holistically with empathy and respect, and signposting colleagues to wellbeing support, employee assistance programmes and services such as occupational health. One of the issues obviously is knowing who hasn't had the vaccine. It may well be data that is simply not collected by your organisation. Employees cannot be compelled to disclose their vaccine status, but the advice from NHS E&I was that they should be encouraged and offered alternative routes for a conversation if necessary. And on the side, we've just set out a few pointers that ACAS have advised might encourage staff to be vaccinated. So what if staff still refuse after you've done your best to try to persuade them? If we move on to the next slide, thank you. So on the 12th of March, further guidance was issued by NHS E&I that stated that if a staff member either declines to disclose their vaccine status or following that one-to-one conversation declines the vaccine, a conversation on job adjustments would need to be conducted to move them into a less exposure-prone setting, and those conversations might require input from local trade union representatives and HR. Now, in reality, I'm conscious that opportunities for redeploying your frontline staff may be really limited. Many of you, I'm sure, will have been involved in moving staff around already for various reasons, maybe health. We've had some queries where members of staff have not been able to wear PPE for their shift duration. Obviously, that reduces other potential opportunities now. I can foresee that some organisations will get to a point where difficult decisions may need to be made. And if you get to that point, and at the risk of this sounding like a bit of a cop-out, I would encourage you to obtain legal advice on the specific individual circumstances, particularly if you're looking at termination of employment. It's highly likely to be challenged in an employment tribunal, and we would need to make sure that there's as much justification there as possible. But it's a situation I can foresee arising. There is a need, of course, to be sensitive to individual situations, and I think NHS E&I recognise that universal coverage of the vaccine may well not be achieved. There might be medical reasons why someone cannot have the vaccine, and I think serious allergies is the one that's mainly cited. Pregnant women are also being advised not to have it unless they're at high risk. A small number of religious groups don't approve of vaccines, but it is a minority, and I'm aware that there has been a lot of collaboration with faith leaders to address concerns. The manufacturers of the 3 vaccines have all confirmed that they don't contain animal products or derivatives, so hopefully that allays some concerns from some religious groups. I think the reality is that the vaccines are still tested on animals. And the Employment Tribunal has found that ethical veganism is a belief worthy of protection under the Equality Act. Whilst these cases are always fact sensitive, I think potentially that could provide a route for someone to allege that either being required to have the vaccine or perhaps move to an alternative location or even dismissed because they won't have the vaccine conflicts with this belief, this sort of ethical veganism or possibly objection to animal testing. In terms of whether being anti-vax generally could be protected as a belief under the Equality Act, I'm not aware that there's any case law directly on that point. To be protected, a belief has to be genuinely held, it has to be cogent, serious, have some cohesion to it, and it has to be important and worthy of respect in a democratic society, and it can't conflict with the rights of others. In terms of the science behind the anti-vax movement, I think previous theories underpinning it have largely been debunked now. But with COVID, it is a fast-moving situation, although in the last couple of weeks we have had additional statements made by the World Health Organization and the European Medicines Agency, specifically in relation to concerns about the Oxford AstraZeneca vaccine. They've reconfirmed again that it is safe. And I would hope that that would assist us in being able to push back any challenges we had about staff trying to assert a protected belief on the basis of an anti-vax statement. If we move on to the next slide, please. So this brings me to the what is being termed the no jab, no job question. The government hasn't legislated to mandate the vaccine, and in its 12th of March communication, NHS E&I said that there were no plans to mandate it. However, they continue to be rumours around this. You may have seen this morning, the Telegraph has reported a leak that Boris Johnson and Matt Hancock have apparently agreed to make the vaccine mandatory for the care sector. I think Matt Hancock has separately commentated that that's actually still under consideration. And I understand that it's still being considered whether the vaccine should be mandated for some frontline NHS workers. The care sector itself has hit the headlines, not least because of this lower rate of take-up, but also some of its major providers have taken steps themselves to make the vaccine mandatory for their members of staff. So Care UK have said that all new staff must have the vaccine. Barchester have said that not only must all new staff have the vaccine, but all existing staff have to have it by the 23rd of April as well. It's a robust line to take, but I think they have quite rightly outlined a number of carve-outs to it. So they've said that they're willing to extend the 23rd of April deadline if there's any data about the safety of the vaccine or its effect on transmission. They've also outlined a number of exemptions, including pregnant members of staff and health-related reasons. And they've been quite open in acknowledging that the approach they're taking does risk discrimination. And they've said that that's not their intention, but it's something that they want to sort of grapple with. There's been a lot of comment on this, and I think the sector is quite divided. The executive director of the Care Home Association has said he thinks it's counterproductive. There are, I understand, 100,000 vacancies in the sector, and he thinks that this may deter new applicants. Unison have also been negative about this approach, but in contrast, the Prime Minister has praised it. Maybe this is because it will take a difficult decision out of his hands if employers themselves start taking steps towards mandating it. We may wonder. I think the fundamental point that I come back to is that Parliament hasn't as yet legislated for this, and particularly for existing employees, you don't have the contractual right to require it. There are legal and ethical considerations to take into account. You know, there's a basic principle that people give free and informed consent to medical treatment, and does mandatory vaccine interfere with this? In terms of the legal risks, you know, I've mentioned the discrimination risks on the previous slide, potential disability discrimination if there's health conditions that are not properly taken account of, potentially religious or philosophical belief issues. Those risks are not absolute. In terms of the claims that are likely to be brought, you will have a defence if you can assert that the action that you're taking is a proportionate means of achieving a legitimate aim. But also existing staff might resign and claim constructive unfair dismissal, alleging that having to have the vaccine is a breach of their contract. There's also a data protection and privacy angle. You're requiring employees to share personal, sensitive information with you. So taking all that into account, and I think particularly for the NHS colleagues on the line, our advice is that persuasion is still the best route to take. Not least given the approach taken by NHS E&I to date. If your organisation is considering mandating it, you will need to think about exemptions to mitigate those discrimination risks. So be prepared to be flexible and to adapt your approach. It will be easier to enforce for new starters, making vaccination a condition of employment, but consider the workplace location of the staff member. Is the vaccine necessary? Take into account other measures like PPE and social distancing. Do they provide the necessary protections instead? I think you would probably need to consult with your unions about making the vaccine mandatory. And ultimately, it's going to be important for you to be able to explain or justify why you need to do this. So building your case with the available data about take-up rates or transmission in your workplace, and those measures that you've already taken to try to persuade people to have the vaccine. So as Stuart said, do pop any questions that you have in the Q&A box, and it's over to Serby now for the next section.
Thank you, Fiona. Good morning, everybody. So I'm going to be looking at how we plan for the future as we come out of lockdown. Many of you will have heard the Prime Minister's announcement on the 22nd of February last month, where he set out the roadmap for all of us coming out of lockdown. The broad direction of travel is pretty clear, and it's subject to the 4 tests. Sorry, Stuart, I should have told you next slide. Thank you. The broad direction of travel is pretty clear, and it's subject to the 4 tests that Fiona has already mentioned. A few points from the Prime Minister's statement, which I think are of particular interest. So firstly, working from home, if you can, guidance is going to remain in place until the 21st of June at the earliest, as is the social distancing guidelines. These are to continue in the same way. The free test kits for workplaces are also to be continued till the end of June. And there's going to be updated plans for responding to local outbreaks. And these are going to be announced next month. What the Prime Minister has made very clear is that the government will not hesitate to reimpose restrictions at both a local and at regional level if evidence suggests that these are necessary to contain or suppress any new variants which escapes the vaccines that are currently being rolled out. And as Fiona has touched on, the 4 reviews that the government is going to be undertaking. So the social distancing, this will be to assess how long do we need to maintain social distancing, the use of the face masks, and also the continued use of having work from home if you can guidance. And all these measures the government has made very clear should remain in place until this review is completed. The second review is obviously around the international travel, and the Global Pandemic Task Force are going to report back on the 12th of April so that we can all plan for the summer. But however, you will have seen the recent press coverage around ministers basically advising against travelling abroad during the summer vacation period. And indeed, Matt Hancock today announcing the £5,000 fine for those people who do travel abroad when they're not permitted to do so. And the third review is around the COVID status certification to enable venues to open up safely, but also being very mindful of how this certification can be used to exclude people, to potentially discriminate, and around maintaining privacy. And the final review is around the major events and the possibility of using testing to facilitate the opening of major events to the general public when the last remaining lockdown restrictions are removed. Next slide, please, Stuart. I'm trying not to say in Chris Whittaker style. Time to think differently. This is going to be a time for us to think very differently as we come out of lockdown. None of us have been in this situation before. You as employers are going to have your own requirements. You're going to be expected to match those with workers' wishes, and especially those workers who have remained at home throughout the lockdown period, either because of shielding or because it is not. It's possible for them to effectively continue working from home, and they haven't returned back to work yet. Those members of staff are going to say, we've been working effectively from home. We've learned how to use the technology that supports us to do so. And, personally, some of them are going to say we've benefited from working from home. There's been reduced commuting time in some cases and the associated costs. And some people are going to say, well, we've had an improved work-life balance and we'd quite like to maintain that. So it's about how can you allow all of that, allowing for the flexibility whilst maintaining productivity. So that nice segues me into the next slide, which is about dealing with flexible working requests. You'll have to be prepared as we come out of lockdown for an increase in formal requests under the statutory regime. It's going to be harder for you where your members of staff have been working from home and make formal requests to continue working from home, either on a full-time basis or on a part-time basis. It's going to be difficult for you to just, in the past it would have been easy to say, for reasons of consistency and business service, etc., service users' needs, etc., we need you in the workplace. Now that these individuals have been able to demonstrate that home working is possible and it is effectively being achieved, that argument is going to be much more difficult to hold. We're going to have to, and also you just need to bear in mind that the government still intend to legislate so that flexible working is the default position, and this was already in the pipeline before COVID-19 happened. For those of you who have a flexible working policy, you need to start, as we are coming out of lockdown, thinking about whether or not it is fit for purpose and it needs adapting. And I'll come back to this again in a minute. Given the increase that you are going to face in formal requests to work flexibly, you're going to have pressures placed on your system and have to deal with a high demand of potential requests to work flexibly. And you're going to have to think about what systems you put in place to deal with this demand to ensure that they are being dealt with in a timely way and in line with the statutory regime. And finally, in order to, Stuart, go back to the slide, I haven't moved yet. Thank you. In order to ensure fairness and consistency, a clear and centralised process is preferable, rather than a system which allows individual managers across the business to potentially make subjective decisions on whether or not to grant flexible working requests, and the risk that this may give rise to potential claims for less favourable treatment under the Equality Act. Next slide, Stuart. Thank you. Looking at the statutory regime for dealing with the right to request flexible working. So employees with at least 26 weeks continuous service can make a request to work flexibly. It can be for any reason. The request has to be written, so it must be dated. It must set out what it is that they're requesting, what flexible working arrangement they're asking for. And it must set out what the impact on the business is going to be. You as employers must notify that employee of your decision, including the right to appeal. And all of this has to be done within the decision period, which is 3 months from when that written request is made. There can only be one request made in a 12-month period. And once you agree to that request, this is a permanent change to the contract of employment, unless you make it very clear that it's a temporary change for a fixed period of time. Next slide, please, Stuart. Thank you. Looking at the right to request flexibly and the reasons that you can cite as for refusing a request that is made formally, there are 8 reasons, and you can rely on one or more of those 8 reasons. The first one is the burden of additional costs as a result of, are there going to be additional costs if you agree to that request? The second one is the detrimental effect on the ability to meet customer demand. So for yourselves, most of you guys, the services that you are providing, will it have any impact on that? The third is the inability to reorganize work among existing staff. I'm not sure that's going to be really a one to rely on if people have already been effectively working from home. The fourth one, inability to recruit additional staff. Fifth one, the detrimental impact on quality, and the sixth one, detrimental impact on performance. And if you've had members of staff who have been working from home and there has been no detrimental impact on quality and performance, it's going to make it much harder for you to rely on these reasons to argue that you cannot agree to the request. Insufficiency of work during the periods of the employee proposes to work. And finally, any planned structural changes that you may have in the pipeline or are envisaging, which could have an impact on your ability to agree to the request to formally work flexibly. Next slide, please. Looking at how to continue to support employees working from home. So if we go to the next slide, communication is obviously important. It's the key to creating an environment where worries can be shared. And it's really important, and we've all been doing it, and I'm sure that there's so much literature out there about how to support well-being, etc. Mind have talked about doing temperature checks at the start of meetings. So they say, you should undertake regular temperature checks at the beginning of meetings as a great way to see how the team is doing and encourage a culture of openness between you and your staff members. So you may want to ask people to put themselves on a scale of 1 to 5, 1 being good, 5 being poor, of how they're feeling, or compare how they're feeling to the weather, sunny being good, windy being not so good, or rainy not being not so good, unless you know you do like the rain and you prefer that to the sun. It's important to initiate and encourage work breaks and building in time for social support. So it's not only just having those regular check-ins, but as a team-wide and individual basis, looking at people's workloads and looking at their well-being in the round. It's crucial to listen to your employees, listen to the pressures that they're facing. What is it that they value from their job? What is it that they no longer value from their job? What's their feedback on the support that they have had during the lockdown period, and what support are they looking for as we come out of the lockdown period? And it's helpful for managers if they can act as role models for any self-care strategies. At Mills Reeve, we have regular wellbeing catch-ups meetings. We have them for all staff, or we have them for people living alone. We have them for people who have children. We have them for people who have disabilities. And they have really proved really successful and useful for staff to openly speak in a forum with their colleagues, and they don't have to be on the same level as them. Everyone attends these meetings, from quite senior up in the organisation to lower level jobs, and just we all pitch in and we try and support each other as best as we can. We also have a message that is regularly pops up on our screens from our diversity, inclusion and wellbeing manager, which basically says, do you need to talk? And it reminds us that we have the facility to speak to one of the nominated wellbeing supporters that we have in the firm, or that we can join one of the weekly catch-up sessions that I've just talked about, that we can contact HR, or that we can obtain support from the Employee Assistance Programme. So just some food for thought there. Next slide, please, Stuart. So looking at the policies and training. So as I've said, as we're coming out of lockdown, you're probably going to need to look at whether or not your flexible working policies are fit for purpose. So for example, the right to formally request flexible working is limited to those employees who have who have been continuously employed for 26 weeks or more. Should this be opened up much wider, so it's not just limited to those employees who have 26 weeks service or more? Looking at your organisation's long-term plans for staff returning back to the workplace. How does this fit into your flexible working policies? Are those long-term plans reflected in your flexible working plan policies? And how are you going to deal with the increase in demand for formal requests that you're going to be receiving? So at Mills Reeve, we've replaced the first come, first serve basis approach with a system whereby all the requests received within a certain period will be considered together in the round. Next slide. Oh, sorry, before you go to the next slide, sorry, I just wanted to say it's really important in terms of training around mental health issues, mental health itself, that you do think about, I'm teaching you to suck eggs, but clearly mental health is a big issue, and it will continue to remain, as we've heard from all the research that's been done, continue to remain a big issue going forward as we all come out of lockdown. And it's about providing that training for managers and staff and support to managers to continue to be able to manage remotely as we are gradually coming out to lockdown. We have no idea when this process will come to an end at this point in time. Next slide, please, Stuart. Thank you. So in terms of the specific role of HR, so yourselves, what can you do to talk to your managers, talk to the managers that you're working with, ask them to establish how are their teams doing, what resources have they found helpful during the lockdown period, what resources Will they continue to find helpful, or do you need to look at things in a different way? What further support do they need? And there's a dearth of literature out there, either from the CIPD, from NHS employers, from Mind, etc. So it's really useful investing in looking at what it is that can be done to help managers to effectively manage their teams as we are coming out of this really difficult period, and looking at providing tailored advice to complex situations for those staff who have had mental health conditions or have developed mental health conditions during this period. What support can you provide the managers to assist in these situations? So, for example, assisting with referrals to occupational health, or through the employee assistance programs, and supporting managers to have sensitive conversations with their staff members. It's not easy. And if we go to the next slide, I just wanted to share with you some questions which Mind and the CIPD have developed and have published in the Mental Health Guidance for Managers, which they've produced together. You know, reading those questions, when I first read them, I thought, oh, they're quite simplistic, aren't they? A bit noddy level. Then I looked at them again and I thought, do you know, how many times am I asked, how are you doing at the moment? I'm asked, how are you? How was your weekend? But really, how are you doing at the moment? And maybe the answer may not be anything more than, yeah, fine. But if you continue to invest in asking these kind of questions, you know, is there anything I can do to help you? And what support do you think might help you as a manager to deal with the situation that you find yourself in? What would you like to see happen? How would you like to see it happen? Whilst they sound really simplistic questions, these kind of check-in questions are really helpful in enabling you to check the temperature of your staff group. And on that note, thank you very much for listening. And I'm going to hand over, I think, to Stuart. Is that right?
That's right. Thanks, Sebi. We'll try and do another Menti question briefly on home working now. So if people can see that on their screens, hopefully now. So for your organisation, what's been good about increased home working? So what are the positives about increased home working? Hopefully people, that's the slide people can see. The answers are starting to come through. The lower sickness absence, so I've done a few of these talks, and that's something that's kind of markedly come through from managers commenting on the fact that there's been lower sickness absence from increased home working, which is an interesting one. And then work-life balance, clearly a big issue. Okay, a couple more minutes, and then I'm going to just quickly look at some of the kind of challenges for your organisation from home working. So I'll move on to the next slide. So from your organisation's perspective, rank these issues in terms of difficulty in respect of increased home working. So which is the most difficult and which is the easiest? Is it maintaining quality of work that's most difficult? Is ensuring health and safety from home working the most difficult? And so on. So if you can have a go at that, that would be great. Hopefully the answers will come through soon. So at the moment, maintaining employee wellbeing, so sitting in with what Serbia was saying a few moments ago. Providing equipment, so providing safe equipment. So this is one of those debates. Did you just, people take their stuff from their workplace, or did you have to duplicate up with the equipment that was being given to staff? So, but interestingly, there not too many concerns about quality of work or productivity, which has always been historically one of the reasons that people were reluctant to allow flexible working. Okay, thank you for that. I'm going to now hopefully go back to the slide deck. And to diversity, inclusion and wellbeing, and to hand over to Andrew. Morning, Andrew.
Thanks, Stuart. Good morning, everyone. Thank you for coming, even if only virtually. So we identified right at the beginning of this session, in the first of the word clouds, we identified wellbeing as a key priority, and diversity and inclusion is a fundamental part of that, as we've heard from Serbi and so on, in terms of things like flexible working. It's also very high up the agenda for a number of reasons nationally at the moment, and we'll talk about the current position. We'll talk about some cases, and we'll talk about the government's stated priorities on this. Stuart, if we could go on to the next slide, please. Thanks. So I'm going to start by talking about the workforce race equality standard in the NHS, and I'm conscious of the fact that that's one large part of where people attending today have come from, but not the whole of it. But the NHS is a good indicator of where things are and where things are going in the current sort of circumstances. And the 2020 data for the workforce race equality standard was published last month, February 2021, and it makes really uncomfortable reading. And this was recognised. Purana Issa, we've name checked her already today, the Chief People Officer, in the sort of the opening to the report, notes this and says these findings, the events of this year, show the need for equality and inclusion to be intrinsic to everything we do. And the People Plan clearly sets out the need to give these issues the same emphasis as we would any other NHS priority. And that's really, really fundamental. Any other NHS priority. That's really, really important. And the events of this year that she's talked about, the context that we talk about, that's obviously against the backdrop of the COVID-19 pandemic and the well-publicised and quite horrendous disparity in impact that COVID-19 has had on different groups in the community. But it's also in the context of the Black Lives Matter movement and the awareness that's being spread more generally off the back of that, and from a gender perspective, recent events that are still really raw in everybody's minds. Stuart, if we can go on to the next slide, please. So the key findings in the report, some of them are identified there on that slide. So 21% of NHS staff are from Black and minority ethnic background, and that's an increase from 17.7% in 2016. We refer there to the 42% increase in Black and minority ethnic people working in very senior manager roles since 2017, which on the face of it looks great. But drilling down as a proportion of the total, that's still only a rise or an increase from 5.3% of the entire VSM cohort to 6.8% over the same period. There's a reference to a 22% increase in Black and minority ethnic trust board members since 2019, and board membership has gone up from 7.1% of the cohort in 2016 to 10% now. Alarming. Sorry, it's just popped up on my screen inviting me to join this meeting. Alarmingly, 30.3% of Black and minority ethnic staff report harassment or bullying or abuse from patients or relatives or the public, compared to 27.9% of white staff. And that figure for Black and minority ethnic staff has gone up since 2016, whereas it's gone down for white colleagues. Perhaps even more alarming, and not actually on the slide, is the the respective figures of 28.4% of staff reporting harassment, bullying or abuse from colleagues where they are from a black and minority ethnic background, compared to just over 23% for white staff. And again, the BME figure is going up, only marginally, but it is going up, whereas the figure for white colleagues is going down. Just before I reached the end of that slide, obviously, but before I sort of whiz on, a couple of other things that have arisen from the report. So 14.5% of black and minority ethnic staff report personally experiencing discrimination at work from a manager or a team leader or other colleagues, compared to 6% of white staff. That's a huge difference. With white applicants 1.6 times more likely to be appointed having been shortlisted than black and minority ethnic candidates. Black and minority ethnic staff more likely to enter formal disciplinary processes, and white staff more likely to access or be able to access non-mandatory training and CPD. So there are really big discrepancies. And so the key lessons from this, some of these things are identified as priorities in the report. But I think fundamentally we would say equality, and the report refers to this, equality should be the professional and moral obligation of every NHS leader. That's a fundamental obligation, and it's reflected in the quotation from Purana at the beginning when I started talking about this. The other thing is that no organisation is doing everything well. There are lots of other organisations that are models of good practice in certain areas, but there's learning to be developed in all areas. And the third is that when we look at the most at-risk groups, so in terms of being likelihood to experience discrimination, likelihood to enter into disciplinary processes, black and minority ethnic staff are overrepresented in most of those at-risk groups. And so the report identifies key targets or key work projects, if you like, for that need to be undertaken across the NHS. So increasing BME representation at band 8 level and above in terms of agenda for change, addressing the wide variation in underrepresentation according to region and trust type, because it's not a uniform picture. Overhauling recruitment practices to ensure that the workforce reflects the diversity of the communities that individual organisations serve. Eliminating the ethnicity gap in formal disciplinary processes is identified as being an absolutely vital action under the People Plan. And a whole host of other targets and areas for learning within HR and management practice and so on. So if we can go on to the next slide. I'm going to talk about two key cases that sort of put some flesh on the bones of, I suppose, of the discussion of diversity, inclusion, discrimination, and so on. And the first on the next slide is LA UK Limited versus Galen, which was published last month. It's a case that went to the Employment Appeal Tribunal. And Mr. Galen describes himself as being of Indian origin. He was employed as a senior data analyst. And after his employment ended, he complained that he'd been subjected to racial harassment by a colleague who's referred to as Mr. P. The employer, LA, investigated. They found that Mr. P had made racist comments. And Mr. P said, as is often the way, they were just racial banter. If we could ban one word, I think we'd probably ban the word banter as a defence. Mr. Galen brought a claim for direct race discrimination and harassment related to race, and the tribunal upheld the claim as it related to harassment related to race. And the tribunal found that Mr. P had made comments to the effect that Mr. Galen should go and work in a corner shop, made negative comments about the colour of his skin, made comments about him driving a Mercedes, in inverted commas, like all Indians, and he was asked why he was in the country. And the tribunal found that 2 managers overheard a number of the comments that had been made but took no action, and they didn't properly address the issue with Mr. P or raise a matter with HR. Now, in defending the claim, the employer ran the argument, which is open to employers, that it took all reasonable steps to prevent the employee, in this case Mr. P, from doing the discriminatory thing. And so in running that, the tribunal then has to consider first what actual steps have been taken by the employer, and second, whether there were any other reasonable steps that the employer should have taken to address this, taking into account effectiveness, cost, practicality, and so on and so forth. And remember, this is all about steps taken to prevent things happening. It's not how it reacts subsequently. And in this case, the employer, LA, relied on its policies and training that it provided to employers and managers. And the Employment Tribunal said that that wasn't nearly enough to count as taking all reasonable steps. The training was stale, it was no longer effective, it should have been refreshed. And Mr. Galen was successful. LA appealed to the Employment Appeal Tribunal, and the Employment Appeal Tribunal agreed with the original tribunal. And they looked at it in some detail and noted that, yes, the equality training had taken place, but it had taken place a year and 8 months before Mr. Galen began his employment, and around 2 years and 8 months before he was dismissed for poor performance. And the EAT said that a reasonable step would have been to refresh that training. The fact that it needed to be refreshed was quite obvious from Mr. P's comment, which he thought, or said he thought, was no more than banter. And it was obvious from the way that the managers failed to properly react to what had happened. The training had made clear to employees what they should do if they heard unacceptable remarks, and they all followed to fail the guidance. Sorry, all failed to follow the guidance. If we can go on to the next slide, please, Stuart. And so in terms of the practical implications of that, and this is a conversation that we would have on a fairly regular basis, I think, that the reasonable steps defence, first of all, it's not an attractive defence to run, but it's always an option as a last resort if the employer finds itself in a sticky situation. But it's a difficult defence, and the threshold for it is very high. And this case particularly reminds us of the importance of making sure that we provide high quality, regular training on equality and diversity, which is effective in changing behaviours and the culture within our organisations. Training has to be reviewed, it has to be refreshed regularly, and training programmes have to be rolled out on a regular basis. And in this case, the judge talked about annual training being sort of the gold standard, if we like. And the EAT made some quite pithy comments about this. In terms of the quality of the training, the EAT said, if the training involves no more than gathering employees together and saying, here's your harassment training, don't harass people, now everyone back to work, then it's not going to work and it's not going to last. And they said that brief and superficial training was never going to have a substantial effect in preventing harassment. Thorough, forcefully presented training is more likely to be effective and to last longer. So from all of this, we would say, we also need to monitor whether the training is actually making a difference. Are issues being reported? Are incidents or allegations of discrimination reducing? Are we seeing fewer grievances? Are employees showing that they understand the importance of preventing discrimination and the role that they play, that each of them plays in that? Because if we can show that, then that is supportive of the reasonable steps defence. But of course, training is only one aspect of that. And policies and procedures, the general culture, the overall culture, the values of the organisation all play a part in that. And so in that case, for example, the employer had an anti-bullying and harassment procedure that didn't refer to harassment or mention race. So it wasn't up to scratch. The second case that I wanted to talk about, and thank you, Stuart, for moving us on to that slide, is Paige and the NHS Trust Development Authority. And you may well have seen some of this in the news, because it goes to, it's quite instructive in terms of the limits of free speech in senior roles. And it goes to, again, that vexed question of how we balance protected characteristics. In this case, it was Mr. Paige, who was a practicing Christian and claimed that he'd been discriminated against on the grounds of his religion. And on the other hand, same-sex couples who might want to engage in the adoption process. So Paige had been a non-executive director of an NHS trust. He was a lay magistrate, and he actually brought claims against both the TDA and the state in relation to the loss of a magistrate role. And he was going through a process that took us to the Court of Appeal to try and overturn employment tribunal decisions that said he hadn't been discriminated against. And in relation to the NHS Trust Development Authority, the Court of Appeal said, so it's very authoritative, he hadn't been discriminated against when disciplinary action was taken, because he had, without prior notice to the trust, given media interviews in which he'd expressed views about same-sex adoption and homosexuality which were liable to impact on the trust's ability to engage with gay service users. And at the same time, he'd shown no insight into why that was even problematic. And so the reason for the disciplinary action hadn't been because he was a Christian or because he believed it was in a child's best interest to be brought up by a mother and father, but it was the way in which he expressed these views in a very public forum and potentially undermined the work of the important work of the trust. And in relation to his claim against the Lord Chancellor, again, the same part of the Court of Appeal concluded that the Lord Chancellor and the Lord Chief Justice hadn't victimised him by removing him from office after he gave a TV interview in which he expressed his objection as a Christian, as he saw it, to same-sex couples adopting children. And again, the Court of Appeal said he wasn't removed for the protected act of alleging that he'd been discriminated against, but for publicly declaring that in cases involving adoption by same-sex couples, he would proceed not on the basis of the law that applied to everyone and the evidence that was available, but on the basis of his own beliefs. And the Lord Chancellor, the Lord Chief Justice were entitled to see that as being sufficiently problematic as to justify terminating his engagement. And some, if we can go on to the next slide, please, Stuart. And some of the comments in the Court of Appeal are really quite helpful or quite instructive in terms of practical implications. And we've said there on the slide that employers are entitled to limit the freedom of expression of their staff and their senior staff where it's going to have an impact on its relationship with its client group, with the service it provides, and so on. And in this case, there were really important factors. So this isn't a sort of a catch-all case that says we can dismiss in every case where somebody's outspoken. The statements were made in public and to the media. They were particularly sensitive, and he was in a very high-profile position, which had ran the risk of affecting the service. And the Court of Appeal said the extent to which it's legitimate to expect a person holding a senior role to refrain from expressing views which may upset a section of the public is a delicate question, and it can only be decided by reference to the facts of each particular case. They said it was right to acknowledge that Paige had a particular interest in expressing publicly his views about same-sex adoption, particularly in the context of his removal as a magistrate, and that's a legitimate matter for public debate. And so, in that sense, but going on in the media wasn't gratuitous. And they also noted that he was quite calm. He was temperate in what he said. So it wasn't an obvious case where it wasn't a slam dunk for the employer. But they said there were some significant issues with it. So, for example, the way he expressed his views was far more than his lawyer, his barrister suggested that he'd expressed a sceptical opinion on same-sex adoptions. But it went far beyond that, because he talked about his views on same-sex marriage. He referred to, in inverted commas, homosexual activity. And so they were far more likely to cause offence and far more likely to be open to misinterpretation than had he just been discussing the very narrow issues. They were particularly concerned that the trust had a board member who was expressing views about homosexuality that might deter mentally ill gay people in the catchment area from engaging with its service. And that goes to the heart of what the organisation does. It threatens the work of the organisation. And they also looked at, and I think this is good guidance, they looked at the question of whether or not there was a way forward that could have respected both parties' interests. So, for example, the trust and the authority together could have accepted that it was okay for him to express his views about same-sex adoption, but he needed to understand and he needed to give credence to the importance of avoiding damage in the relationship between the trust and the people who it served. And so, in the absence of that, there was no way back. And so his claims, his appeals failed. So if we can go on to the next slide, Stuart. That then all, I suppose, is context within which the broader equality agenda is being pursued by the government. And I think it's safe to say that equality is very high on the government's stated agenda. And that is reflected in a number of areas of development that we expect in employment law over the coming year. In parliamentary parlance, when parliamentary time allows. So clearly there are other issues. It's a bit of a bun fight for parliamentary time. But that slide, the slide we've got there, shows the different strands of the debate that's likely to take place and where the developments are likely to take place in Parliament. If we can go on to the next slide, Stuart. And one thing that's actually not on the slide is ethnicity pay reporting. So Parliament's going to be debating whether to widen the scope of pay gap reporting beyond gender, so that the pay gap between employees of different ethnic groups must also be published. There are difficult issues around that. For example, whether we report between white on the one hand and all BME staff on the other, or whether we break down according to ethnic groups, and how to categorise. But that's on the agenda. Next is, and the first thing on that slide, measures to tackle sexual harassment. Consultations have taken place, and we're waiting for the government to confirm what action it intends to take in terms of combating sexual harassment. One of the original proposals was that employers should be put under a mandatory duty to prevent harassment in the workplace with substantial financial penalties if they don't, as a way of making sure that people take it as seriously as the government wants it to be taken. There's also been a proposal to extend the time limit for bringing all workplace discrimination and harassment claims from 3 to 6 months, which would have two effects, or two purposes, I suppose. One, to allow employers and employees to pursue alternative means of resolving the problems first, and to allow internal grievance procedures to be completed. So that's very much on the agenda. The second is in relation to restrictions on the use of non-disclosure agreements, gagging clauses, in relation to employment contracts and settlement agreements. And the Me Too movement threw into pretty sharp relief some of the unethical or inappropriate uses of non-disclosure agreements, either as a threat or to silence people who've been treated inappropriately, Harvey Weinstein being only the most obvious of those cases. And the government said it's going to introduce legislation to curb the use of NDAs in employment contracts and settlement agreements, where those settlement agreements relate to cases of discrimination and harassment. And the rationale behind it is that all employees who have experienced discrimination or harassment need to have a meaningful route of redress. And there's a power imbalance in any of those sorts of negotiations. And the government plans to make it illegal for employers to prevent individuals making disclosures to certain bodies and to certain people, and to make it compulsory for individuals asked to sign a non-disclosure agreement to get independent legal advice first, in the same way as you have to when you enter into a settlement agreement, and so on. The last thing on that slide is the discussion around extending redundancy protection for women and new parents. And the plan there, we all know at the moment that before we make a woman who's on maternity leave redundant, the employer has to offer her a suitable alternative vacancy. And the plan is that this will apply from the point that the employee notifies the employer of their pregnancy until 6 months after the end of their maternity leave. And the Equality and Human Rights Commission have asked if this be implemented as a matter of urgency, given the rise in redundancies as a result of COVID. And then if we can go on to my last slide, I think my last slide. And Serdy's kind of slightly stole my thunder with this one, but that's all right. The government, the Conservative Party said in the past that it's committed to making flexible working the default position for all employment contracts, unless an employer has a good reason. So we're expecting a consultation on that. And the CIPD at the start of last month launched a new campaign calling for the right to request flexible working to be a day one right. So we talked about the amount, the 26 weeks you have to be employed for before you can make the request at the moment. Because it had research which found that from 2,000 workers surveyed, 50% said that they didn't have flexible working arrangements, such as flexi time or part-time working, and 20% said that their organisation didn't offer any flexible working arrangements at all. And finally, in relation to neonatal leave, the government's proposed a new right to support parents of premature or sick babies. The reason, they estimate around 100,000 babies a year are admitted to neonatal care, and that creates huge issues for their parents from an employment perspective. And the government's proposed 1 week's leave, neonatal leave, for each week that the baby is in neonatal care, subject to a cap, tacked on to the end of the parent's maternity or paternity leave, paid at the usual statutory rate, and subject to the usual qualifying conditions as paternity pay. And that's my whistle stop through equality and diversity. So I shall hand you back.
Morning, everyone. I can still see Andrew on my screen, so I hope you can see me, Emma Pattenden. So I'm going to cover two recent developments which have just been just come to light in the past few weeks. And the first of those is the disapplication of the cap on public sector exit payments. So this was a cap which was put in place only from the 4th of November last year of £95,000 on public sector exit payments. And it was trailed over a long period of time, and there was quite a lengthy consultation period. And it was only in place very briefly before last month in February, the Treasury issued a direction disapplying the cap. And the kind of context around that is it had been subject to challenge by the BMA, but also by some of the national unions who put in judicial review applications, which were due to be heard at the end of this month. So all of that fell away because the Treasury issued a direction disapplying the cap. There was accompanying guidance issued at the same time, which suggested that employees who'd been affected by the cap should contact their former employers to ask them to pay the excess. So the direction not only disapplied the cap from the date it was issued, but it also meant that any payments which had applied the cap between 4th of November and 4th of November 2020 and 12th of February 2021 shouldn't have applied the cap, and those who'd been subject to the cap were entitled to have their excess entitlement paid to them. That's been confirmed in regulations formally revoking the cap, which came into effect last week. And that includes a provision obliging public authorities to pay back the amount, so any entitlement in excess of the cap, plus interest at the judgment rate, which is 8% per annum, albeit there's no time limit for those payments to be made. The HM Treasury guidance did also make clear, though, that exit payments do still need to deliver value for money for the taxpayer and need to be fair and proportionate. So they will be bringing forward proposals to tackle what they describe as unjustified exit payments. So we're awaiting further guidance on that. But in the meantime, the statutory cap itself has been removed with effect from last month and retrospectively. The next issue that I wanted to look at was holiday pay. So just to move on to my first holiday pay slide. Some of you may all be familiar with the Flowers holiday pay case, which we've been involved with for a number of years. So this is a case that was brought by a group of ambulance workers who claimed that their holiday pay should include payments to reflect overtime pay that they'd received, both for shift overruns and also for voluntary overtime that they'd worked. And they claimed this both by reference to their contract, which was the NHS Agenda for Change Terms and Conditions, which applies nationally, and also under the European Working Time Directive. So we've most recently, in this case, attended the Court of Appeal, and the case was due to attend the Supreme Court in June of this year. But there has been a recent development in that a national resolution has now been achieved, and it's been agreed by NHS Staff Council. And this follows on from months of negotiations between NHS employers on behalf of the Department of Health and Social Care, NHS England Stroke Improvement, and also the national staff side, national trade unions. So in terms of the scope of that national resolution, they've published a framework agreement. It applies to England only. So I think Scotland already had a deal in place, and it looks as if Wales and Northern Ireland may now follow suit. So the framework agreement that's been published applies to England only, and it applies only to NHS employees who are on the National Agenda for Change Terms and Conditions. And it applies to those who work hours which are worked regularly in excess of their standard hours pursuant to their contract of employment. So basically, it encapsulates all types of overtime, so including voluntary overtime and other types of overtime as well. It applies to part-time employees as well as full-time employees, but it doesn't include bank staff. Usually NHS banks have their own arrangements for holiday pay in any event, but the guidance makes clear it doesn't apply to NHS bank staff. So in addition to the framework agreement, FAQ's document has been published on the NHS employers website together with a slide pack, and they've also set up some webinars which HRDs can attend so that they can talk through any queries. Just moving on to my next slide, please, Stuart. Oh, thanks. So the purpose of the framework agreement is to try to address historical liability across the NHS. And it goes about that by providing for corrective payments to be made for those who are eligible. So in order to be eligible for a corrective payment to be made, an individual needs to be employed by an NHS employer on the 31st of March 2021. It doesn't necessarily matter if they've moved about within the NHS up to that date, as long as they're employed by the NHS on that date or by an NHS employer on that date. And then provided that they are, employers need to look at what overtime has been worked in what's known as the corrective payment period, which is the last 2 NHS financial years. So that's 1st of April 2019 to 31st of March 2020, and 1st of April 2020 to 31st of March 2021. And provided that an individual has been paid overtime pay in at least 4 out of 12 of the months in one or either of those financial years, they'll be entitled to a corrective payment. So they may be entitled to a corrective payment in respect of both years, or just 1 year, one or the other of the years. It doesn't matter how many or how few times they've worked overtime within any particular month, provided that they can show that they've received an overtime payment in a month that counts as 1 month out of the 4 that they need to show. There will also be, in terms of eligibility, there's also going to be some additional guidance issued by the Department of Health and Social Care around the implementation of corrective payments, taking into account equality issues. So we haven't yet seen that, but the guidance suggests that if someone isn't able to demonstrate they meet the eligibility criteria because of, say, a period of maternity leave or long-term sickness absence because of disability, potentially they may need to be an adjustment to the usual eligibility criteria to enable them to be paid. So for those individuals who meet the eligibility criteria, a payment needs to be made to them of 16% of their total overtime pay received in that corrective payment period. That will be a non-pensionable payment, but it will be subject to deductions for tax and NI in the usual way because it's basically salary. For those NHS employers who have already included some overtime pay in holiday pay, that can be deducted from the corrective payment that needs to be made. And the intention is that all of these payments, if possible, will be made by 30th of September 2021. So the payments will, according to the guidance, be nationally funded, and apparently trusts will be given information from the national payroll system to enable them to identify who's eligible and how much each employee should receive. So in terms of the position going forward, so what should be included in NHS holiday pay going forwards? Well, according to the guidance, the Department of Health and Social Care, NHS employers and NHS England /Improvement are working to produce guidance on the future application of annual leave pay where overtime is regularly worked. That suggests to me that there will be some kind of regularity requirement, perhaps along the lines of that set out in the corrective payment. So it may be that someone needs to have received overtime in 4 months out of 12 in order to qualify going forwards, but we wait to see what the criteria will be. It's not clear yet whether going forwards a percentage will be applied in the way of the corrective payments. It may be that a reference period is used instead because the Agenda for Change terms and conditions require a kind of look back over a retrospective reference period, and apparently there are no plans to amend the wording of Agenda for Change itself. In terms of any existing or ongoing claims, I know that many claims for holiday pay are currently stayed in the Employment Tribunal because they were awaiting the decision of the Supreme Court in June. Particularly, I think there are a few claims stayed in the ambulance sector. So the expectation under the framework agreement is that these claims should be resolved now at local level, and that the trade unions will facilitate that. So provided that reasonable offers are put forward, the trade unions have agreed not to support any further legal claims going forward in respect to the position up to the 31st of March 2021. So I will now hand over to Becky, who's going to talk about 2 recent cases.
Thanks, Emma. Good morning, everybody. So the first case that I'd like to talk about is the long-awaited decision of the Supreme Court on the payment of sleep-ins. So it's Royal Mencap Society and Tomlinson Blake, as I say, of real significance to the care sector. For a long time, there's been a question about whether hours spent either on call or on what is commonly known as a sleep-in attract payment of the national minimum wage for the entirety of the time that the individual is on that shift. And a lot of employers pay a flat allowance for that sleep-in or on-call period, which is obviously some way below what the level of the national minimum wage. So in this case, Mrs. Tomlinson Blake worked for Mencap, and she regularly worked on call sleep-in shifts. During those shifts, she had no specific tasks that she had to carry out, but she did have to remain at home. She could sleep but she was expected to be able to deal with it. And over a period of about 16 months, the court heard that she actually only had to get up, only had to intervene for an emergency 6 times in that 16 months. So she brought a claim and said that she was entitled to the national minimum wage for the entirety of the time that she was on the shift. And the question arose as to whether, for the purposes of the national minimum wage calculation, she was doing what we call time work during that time. And the regulations say that you're doing time work if you're awake for the purposes of working. And so that was the issue that the Supreme Court looked at. And as I say, to the great relief of many organisations, I'm sure, on this webinar, the Supreme Court found that the national minimum wage regulations do draw a basic distinction between working and being available for work. And for the purposes of deciding whether someone is working under the national minimum wage, it doesn't matter if that individual is actually at the direction of the employer during that time or required to follow instructions. So, for instance, there was before this case came to the Supreme Court, we'd previously operated on the basis of a sort of multifactorial test in deciding whether somebody was working while they were on call, and so whether those hours attracted the national minimum wage. And that test involved looking at whether the individual's time was their own while they were there. So could they do other things while they were on the shift? Could they, for instance, drink alcohol? How far from home were they? And those sorts of things. And all of those factors were used to determine whether that person was actually working and therefore doing time work for the purposes of the national minimum wage. So in terms of the practical implications, I think that there was a lot of talk in the press, and some of it may have been a little bit OTT, but there was talk of it kind of decimating the care sector if the decision had gone the wrong way, because there would have been lots of claims, huge numbers of claims for back pay, for sleep-in payments that had accrued over the last 6 years. So the position now is that just because somebody is on your premises and is on call, that doesn't mean that they are entitled to that those hours that they're there all attract the national minimum wage. So it's perfectly acceptable at the moment to carry on paying the flat rate that I'm sure a lot of you pay for that period of on call. The one thing that I would say, the one caution, is that you should make sure that in your contracts of employment there isn't anything that cuts across that. So there's nothing that says actually they should be entitled to a higher rate of pay and so on. But generally really, really good news for the care sector. And then Stuart, if we could change this, you're there already, thank you. So the second case that I want to look at is the Independent Workers Union and the Secretary of State for Work and Pensions. So this concerns Section 44 of the Employment Rights Act, which provides protection from being subject to detriments for raising health and safety issues or for leaving the place of work. So if an individual perceives serious and imminent danger, then they're entitled to leave the premises, and that's what Section 44 says. So the Independent Workers Union has around 5,000 members, and they're generally low-paid members of what commonly become referred to as the gig economy, rather than employees, so workers rather than employees. A large number of the union's members raised issues about not having been given the correct PPE, that the people engaging, or the organisations engaging them, had failed to implement proper social distancing measures, and on some occasions that couriers who were delivering medical supplies, that the packages hadn't been properly and safely packed. So the union sought a declaration via judicial review, and I won't bore you with the technical judicial review mechanisms, but the union sought a declaration that Section 44 of the Employment Rights Act extended to workers as well as employees, and the court agreed that it did. If I could change the slide, please. So in terms of the practical implications of the case, I think the likelihood is that we are going to see some more claims on this basis. Increasingly, we're hearing talk from the unions about Section 44, although we haven't actually, as far as I'm aware, had any actual claims, not dealing yet with any actual claims for clients, but certainly there's an increase in the talk about it. And the rest of it, I think, really is common sense. So I'm sure this is happening anyway, but generally, and where possible, making sure that staff have equipment to enable them to protect themselves and do their job safely. It's worth noting, I think, that this case does follow the trend of a number of other cases recently in terms of broadening out protections and rights that we have previously understood to apply only to employees, to workers. So for instance, last year there was a decision on TUPE. We as employment lawyers for many years have been working on the basis that it was only employees who transfer, and then there was a case that said that in certain circumstances actually it can extend to workers as well as employees. And then just finally, it's just worth mentioning that there was some talk about an appeal of the Independent Workers Union decision by the government, but in fact they've now accepted the position, so that the protection from detriment for the health and safety issues should extend to workers, and they're putting in place some regulations that come into effect on the 31st of May that reflect that change. Over to Jog, thank you.
Sorry, I forgot to unmute myself. Thank you, Becky, and thank you to our presenters. We do have some time for questions. I appreciate some of you may need to pop off. So if you're leaving us now, thank you for listening, and we will be sending the slides over to you in a questionnaire. So moving on to our first question, one for Fiona. So with regard to the impact of COVID, clearly some staff members will suffer with symptoms related to long COVID. So how will a good employer manage those symptoms in the context of a capability and sickness procedure? Will the triggers, for example, be operative in those circumstances?
Yeah, thank you for it. It's a good question, and I know that some of our clients are grappling with that at the moment. I mean, in terms of long COVID, I think the more likely situation is that you've got someone absent from work for one extended period of time rather than, you know, persistent short-term absence where the triggers would apply. When you're dealing with long-term absence, you know, the usual principles are going to apply. You're going to have to consult with the staff member. You're going to have to obtain medical advice about their prognosis and returning to work. Can you consider redeployment, alternative duties, and things like that? And ultimately, you know, a decision will have to be made about whether a return to work in some capacity in the foreseeable future is foreseeable or not, and how long you know, this situation can be sustained by the trust. I think some of our clients are getting to the point now where some of their employees have sadly been absent from work for a year or more, and there is no foreseeability about when they may be able to return to work. You know, conversations around ill health, retirement, and things like that are going to have to take place. But I think you have to fall back on the basic principles for managing the long COVID cases.
Great, thank you, Fiona. And a health and safety question for Stuart. So increasingly, the question of what an employee's base will arise. So if you have an employee who's working 3 days a week from home, and 2 days from their employer's location, do the health and safety obligations vary if they're working from home, and do they become contractually a home-based worker?
I think the easiest way to look at that question is just look at the statutory duty under the health and safety legislation. So that's to take all reasonably practicable steps to ensure the health and safety of someone at work. So if for some of the time the person's at home, you still need to take the reasonably practical steps to ensure their health and safety at home, and similarly if they're in the workplace. So I wouldn't get too hung up about the contractual position around that. I'd look at the statutory position to ensure a safe place of work. And
employers should have reserved a right to a mobility clause anyway, in terms of where employees are working from, and that should obviously cover home working. Expenses might be a practical issue, so it might be worthwhile looking at how employees claim expenses. So moving on to equality, a top tip actually from Andrew and Serby. There is a risk that when embedding equality, that senior managers are seen as paying lip service and not making any real change to the culture of an organisation. So firstly, Serby, have you got any top tip as to how we change the mindset of an organisation to truly embed equality? $1 million question, really.
Oh my God, that's a really good question. Top tip. I just think it's, for me, and it's not just for the NHS, I think it's for everyone. I think it's just having an open mind, having a very open mind, and not, we all work in highly pressurized environments and resource strapped environments, and especially given the past year, we're you know, if we genuinely put our hand on our heart, we're exhausted. So you're dealing with managers at the moment who are very tired, who are exhausted, and frankly are just thinking, you know, I'm doing the best I can. But if in some way it can be, I don't know, explained to managers the benefits of empowering your employees to speak up, to talk about and share concerns that they have, it's just going to make their job much easier in the long run. It is $1 million question. I don't think there's a right or wrong answer.
Yeah,
I just think
it's absolutely right, though, Serby. The benefit of those questions is the important key. So, Andrew, are you able to add to that question as well?
Oh, I thought I might have got away with it. I'm gonna quote Nike. Obviously, spend an awful lot on their advertising agencies and come up with some great slogans. So I'm going to quote Nike: "Just do it." I think there's something really, really powerful about modeling it, leading it. You know, showing, making challenge and accountability and just an integral part of everyday life. Yeah. I think that's the thing. I think.
Again, wise words.
One of those things. Sorry, I'm waffling on now. But yeah, there's a book by Ibram Kendi, I think it's called How to Be an Anti-Racist, and he says the opposite of racist isn't not racist; it's anti-racist. It's about actively making a stand, actively living the values. And I think that's really important. But I've gone off on one. Sorry.
That's very, very helpful, and indeed, people do feel much more open to have those conversations and to challenge people, but the challenge will take a lot longer. I appreciate that. A question for any of our panel members. What about guidance in terms of presenteeism? Are there any top tips there? Has ACAS issued any guidance? How do good employers manage this issue? Right, no volunteers.
I did have a quick search. There is no guidance that's been issued by ACAS. I think it's been a phenomenon. It's not a new phenomenon, although it's being talked about a lot at the moment. It's been around for years and years. I don't think there's any top tips other than just the obvious. don't say that the person is faking it. You know, there are lots and lots of people coming into work at the moment when they shouldn't be. And for example, people with mental health problems, you know, it's just so difficult to identify when someone has a mental health problem. It's so easy to mask. And it's just, you know, it's just making sure that you're aware if someone is not performing well or are not delivering as they should be, there may be some background reason why that's happening. So, you know, the obvious example of presenteeism is when you come into work with that kind of splitting headache and you just crack on with the job. So now I just think it's moved on from that. It's probably a little bit more encompassing other conditions that have come out from the COVID period.
Thank you, Serbi. And then we've got our last question, which is a follow-up question for Fiona on long COVID. So if we haven't been triggering long COVID in line with our absence policy, which is the NHS employers guidance says the triggers should not be activated. So if we get to a point where it's no longer sustainable given the level of absence and all alternatives have been exhausted, does this give rise to a potential claim that we've not followed our own policy?
Well, I guess you've been more favourable to the employee, haven't you, by, you know, not following trigger points. I mean, the risk of claims is there, unfortunately. Unfair dismissal if the employee has 2 years service, and disability discrimination claims as well. I think the way to mitigate that, you know, again, is not rushing into taking action and you know, concluding consultation with employees and discussing redeployment with them, and just having your kind of decision making about why it's no longer reasonable for you to, you know, hold the vacancy open for them, etc.
Great, thank you. So a big thank you to our panelists today for their presentations, and for you all for logging on and listening. We know how busy you all are. So we will be sending the slides out together with a questionnaire for you to fill out. We are really interested in knowing if there are any other topics you would like us to cover. And please do contact us directly if you've got any additional questions, or if you've got any other suggestions that you would like to make in terms of topics that we could deliver either for you in your own organisations or in a session similar to this. So thank you for listening, and goodbye for now.